Good afternoon, everybody, and welcome to another episode of BHBA Family Law Presents Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reichstein, I'm Dan Bemmel, financial advisor and certified divorce financial analyst. During each episode of our show, we explore our guest's personal and professional history and dig into a meaningful legal topic. Please continue to join us for our upcoming episodes, always at 12:30 p.m. live on Zoom. We're so excited for our initial 2023 lineup. Peter Walzer on January 4th, Samantha Klein on February 1st, Glenn Schwartz on March 1st, followed by Judge Scott Gordon, Stacey Phillips, Grace Jammer and Michael Hanesab, Aaron Gray and Chelsea Stevens, and Judge Harvey A. Silberman. More to come even later in the year. Lauren?
Thank you, Dan. Good afternoon, everyone. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. The family law section is sponsored by White, Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. All right, that's it for our sponsors, and we can get started.
Thank you, Lauren. Today, we welcome Judge Susan Lopez Giss. After 15 years on the bench, all of it in family law, Judge Lopez Giss is now an in-demand mediator at ADR Services. With a net experience of over 1,000 cases on the bench and hundreds more as a city attorney, definitely safe to say she's seen more than most of our guests, maybe combined. So our intention today is to learn as much as we can, but first, Your Honor, thank you so much for being here with us.
Thank you for having me. It's an honor for me to be part of this. Thank you.
I don't know, it's going to be fun, though. I know the hour is going to fly by. We have so much to get to. Let's start with some big picture reflections on your time on the bench, maybe call the system as a whole, and kind of work backwards from there. So right off the bat, what did you like most about being a judge?
I think, to tell you the truth, once I got out of law school, I was fortunate to have a judicial clerkship. And in those days, there was a separate law and motion department in the Superior and Municipal Court because it was before consolidation. And I worked for a judge who's now deceased, Judge Robert Fainer. And he was a role model and a mentor to me. So I always thought in my mind, I wanted to be a judge. The system is so different now than it was then. I mentioned consolidation, and I had been a city attorney for a number of years, as a prosecutor, 15, and then as general counsel. I litigated a lot of cases, meaning I tried cases, but the concept of being a part of access to justice and hoping to make a change is the one goal I had in becoming a judge. And that is why I asked to go to family law, because I decided when I was first as a city attorney, fortunate to have helped start and write the domestic violence program, which was the first prosecution program of its kind in the country. I decided I wanted to be able to help people going through this process because I didn't like what happened to the children. And so I thought if I could help make a change, I wanted to do that, or at least be a part of the process to make it not so horrible. So I've been fortunate, I think, to do that. I've had colleagues who've also had the same feelings, and the LA Superior Court and the superior supervising judges I had knew that this is where I wanted to be with respect to settlements. And we all have our goals in life to make a difference. This was mine.
You requested a family law assignment, but what kept you there for 15 years?
So when I first had my first meeting with Judge McLaughlin, who was then the presiding judge, I had just become a judge, and I had litigated a very significant case for the Department of Water and Power involving a national marketing firm that resulted in a large recovery because of fraud. And I had been elected or chosen to be one of the 75 top women litigators in the state, which is a big honor, but for government lawyers, it's incredibly big. I think that one of the only other government lawyers on that at that year was Kamala Harris. So good, the lights went out here, but in okay. To follow up, I met with McLaughlin and he had my resume and he said, I'm sure you want to go to complex civil, but we are going to start you at Metro doing DUIs, which I had done a lot of when I was a city attorney. And my husband is was a judge at the time, he's retired, Harvey Giss, and he told me, I said, I'm going to ask for family law. And he said to me, no, don't do that. Don't do that, because that means you'll probably get stuck there. And I said, I want to be stuck there. So when I told that to McLaughlin, he told me, number one, never listen to Harvey. And number two, he called Bob Schneider like immediately. And this is where I want to be. That every day when I was on the bench, I felt challenged, and I felt I was doing something that was more challenging than worrying about money. And certainly there are other former prosecutors on our bench who had lots of felony experience who belonged in criminal. So this is really where I belong.
Why do you think the turnover is so high on the family law bench for others that maybe don't share your perspective?
Well, like I said, my own husband felt it was going to be a dead end. And I think that there is so much emotion in family law. It takes a special breed of person to be an attorney and to handle these cases. Lots of lawyers don't want these cases. And I used to say when I would give a speech in the morning when I first started on the bench, and I said, having done criminal law, you have bad people who come into court who really act very well mannered, very calm. And in family law, you have good people acting bad. And, you know, when in criminal law, most people know the drill. There's, you know, pretty strict rules, and you follow the rules of evidence, and there's jury instructions. But in family law, there is so much discretion. And even though there's a concept or the law is no fault state, people want to tell their story. And so most of what they want to say and most of what they tell you as lawyers, you and I know is never going to get introduced. But that leaves a cauldron that doesn't get any release. And when they walk into court after back and forth between the person that was once their best friend and is now their best enemy, I think it's just a recipe for volatility. And I think most people don't want to deal with that. It's easier when it's just simple jury instructions, simple rules of evidence, and fitting everything into a game plan.
So after those 15 years, you recently retired. What led you to ultimately leave the bench?
So I think there were three factors. ADR started calling me sometime before I retired. And I thought, how do they know I'm ready to retire? I mean, like, I was going to run off to a plastic surgeon. How do they know that I'm ready, you know? And so I kind of put them off. COVID then happened. And I felt that this was not the time to leave because I didn't know what was going to happen to the system. And doing things by virtual hearings were a challenge to me. And especially in family law. And our system initially had kinks in it. And I just didn't know how it was going to play out. The third part that kind of added is I have 7 grandchildren. And I have a daughter-in-law who recently got a very, she's an attorney, got a very high position in the Biden administration. And before she took it, she called me and asked me, would I be willing to come help out? Because my son is a international white collar attorney. And so I think when your daughter-in-law calls you, I mean, you've done something right. And that coincided with another phone call from ADR. And I decided, if not now, when? I mean, when am I going to do it? And it was hard because I loved my assignment. I loved my colleagues. There was never any part of me that felt this wasn't working. It was just an opportunity to have more time with my family, more time to make flexibility, and to also face a new challenge.
So looking back on, you said the system, if you had a magic wand within the budget realities, of course, if you had a magic wand now, and I know you're still close with people there, how would you improve the system? What are maybe your top 3 things that you would do if you could just wave that wand?
Well, I don't know if actually this is within a budget constraint. My first thing I think is that.
Okay, maybe you get a little more money. You get a little more money.
Okay, let me just say this. I've always said that Tom Lewis left the bench because he couldn't stand my crank calls anymore, saying we need more settlement courts. We need more settlement courts. And I believe that settlement should happen earlier rather than later. I'm talking early, like with the first RFO. And I was talking to an attorney about it recently, and they said, well, the declarations of disclosure hadn't been filed yet. And I even spoke to Judge Kaufman about that. And I said, I understand that, but I'm not saying a settlement or a judgment has to be entered that day. But if people have some understanding of where they could be going and what the risks are early on, it might help get them there and even understand the concept of the declaration of disclosure. Number 2, I feel there needs to be a more dedicated restraining order court or courts, because right or wrong, and I don't want to get into philosophical conversations, I see domestic violence being utilized, understandably so, to cut in front of the line with custody issues. And I'm not saying that these are or are not domestic violence cases. They certainly, the definition of domestic violence has expanded so much since I originally wrote the statute. Spandex is too tight for how much it was. And, this legislature just enacted, the coercive control component. And again, to quote Tom Lewis, the legislature tells us what we can't do, but not what we should do. I think if you had judges who understood the law and had a procedure that was uniform and consistent, it would help diffuse the wide attack on the system, because with COVID and everything has basically been jammed into a very small tunnel. The third thing I think I would change is there's so many new judges on the bench. I think that there needs to be an understanding of how judges can control, under Evidence Code 320, the introduction of evidence and the offer of proof, and understand and necessarily narrow the amount of time, because people will make 3-day or 4-day statements as to how long it can be. And there's case law that indicates that you can ask questions and limit people in time, as long as you understand what the issue of proof is. So I'm not criticizing my colleagues, but I know there's been a big turnover. And I think that the notion of how many tools everybody has needs to be focused on earlier on. And I really mean settlements, because you can get rid of a whole lot of cases. One other thing, I know in Arizona, they have a category where if it's a dissolution without children, and we call them summary dissolutions, but if you have cases that have very little to argue over, just a pension, a house, and no kids, or you both agree that what you're going to do with those kids those types of cases should go on a different path, because they're going to resolve quicker. And I think there should be something that's in the initial taken off the petition with respect to programming, that you could identify those cases. I was saying these things 5, 6, 7 years ago, that we should, have a system that recognizes those components and number them differently, but with a different letter or a different symbol.
I want to explore one of the things that you brought up on that wish list or magic wand list about requiring early MSCs or earlier settlement intervention. What types of infrastructures would help get cases to settle earlier or improve the settlement rate off the bat?
You know, I spoke with Judge Kaufman about this. I know she shares, we're kindred spirits on this. I think initially, when the first RFO is set, there should be a mediation set. You know, the DSO system is just an amazing resource. And I think effectively used helps a lot of people, self-represented people particularly, because they're wandering around and they don't even know what to do. And if there's one lawyer and the other one is unrepresented, people have a natural state of distrust. So I really feel that doing it early is important. I would like the court to have some type of a video that it could be online. And when you file your case, you see the video that discusses settlement and discusses what will happen. Something as simple as everything gets divided by 2. I think I mentioned to both of you, I know I mentioned it to some lawyers recently. I did a settlement a number of months back where the litigant said to me early on, okay, fine, I hear you. I'm just going to go find a judge who's going to refuse to divorce us because I don't want the divorce. And a great amount of money had been spent. And this was an incredibly educated, also very well-funded litigant, but did not want the divorce. And I think that when the system, not the lawyer, but the system tells people early on about the right to a divorce, a bifurcation, that it is a no-fault state, that many of the things you want to talk about may not be spoken about. If they hear that early on, it helps program the thoughtful part of our brains. I've often said in the speech I would give during mediation, as human beings, when they come to court, we're all in our fight and flight mode. Look, our lives are upside down. They're not going to have the money. They may not get their children. 10,000 years ago, our ancestors did not sit and wonder, is that or is that not that noise an enemy? They ran. Anybody who didn't run is not our ancestor. Having said that, when you come to court, it is the fear part that's working, not the intellect part, which is directly opposite of what you need when you come to court. You need to be able to think. So I'll tell people, imagine you're not in court, but you're having brain surgery, though you might feel like you're having brain surgery today. And your neurosurgeon walks in, you're laying on the table, and the neurosurgeon's going to have the anesthesiologist put the mask on, and you're find out that your neurosurgeon is in your frame of mind. How comfortable are you having that person open up your head? But that's how people are when they come into their first hearing. I think if they'd talk to someone or saw a video, it would help.
So if that's a shift on the litigant side, what do you think needs to change in terms of judicial philosophy or training on the bench side of things?
I think there has been a historic philosophy that you let the lawyers and the parties take as much time as they want. And even though Elkins and court rules indicate that we should have a judgment within 18 or 24 months, the fact of the matter is the statistics were, I don't know what they are now this year, but historically, 88% of the family law cases are resolved without ever seeing a judge. I mean, and you know that they're resolved in your office, Lauren. You couldn't possibly practice if you had to take 88% of the cases to court. So with that statistic, I think Elkins and the goals are met. The problem is 12% of the cases drive the courts. And I think in the sense of the philosophical shift is the notion that no one wants to tell somebody they can't reconcile. Nobody's going to tell somebody they can't do discovery. But on the other hand, at what cost? Because people have not even ascertained what they're arguing about. The parties have an idea of how much money there is. They're living a certain lifestyle. They know how much theoretically there is. Of course, there's always the gold bullion that somebody hid, in the Seychelles or whatever it is, and the brother-in-law who took a big deposit the night before the petition was filed. That can be dealt with. But case after case, I'll ask the people, how much money have you spent on their attorneys? And they look at their lawyer. And I tell them, no, it came out of your wallet. And here's the bigger question. How far apart are you? They don't have a clue. And they're getting to me late in the case. They don't know. And they tell me a lot. A lot doesn't tell me anything. So I think that my colleagues need to ask those questions earlier and often. But there's a revolving door for my colleagues. The colleagues who know this, Diana and Harvey and Mark Uhas and a number of others who understand this and are adept at this. I'm not suggesting the new ones won't get there, but it isn't something that is necessarily thought about because you're so worried about just getting your first RFO heard. It's a process.
Another question on the system side of things. What's your view on long cause courts? I know there's been a lot of back and forth about adding additional long cause courts to help clear out some of the backlog in the home courts. What's your view on that?
So I believe long cause is the antithesis of settlement. And I totally respect my colleagues who think otherwise. But that old movie, what is it? Field of Dreams, build it and they will come. Add 6 more long cause courts and you're going to get them filled. And you'll have representations that it's 3 days or 4 days, or 5 days. And, some of the evidence is redundant. Some of it won't be introduced. But many of the people who are on the bench don't necessarily have the experience or history of doing motions in limine or going through this evidence because they're brand new. Of course, there are long cause cases. Don't misunderstand. But, again, Tom Lewis and I mean, I think the sun rises and sets on him. I think he's amazing. But I think he and I have a philosophical difference about the notion of getting cases tried and settling. I think far more cases should be settled to open the doors to have long cause. And I do not think there are not long cause cases. There absolutely are. But, 15 years on the bench, many, many cases I was told were long cause. To quote Porgy and Bess, ain't necessarily so.
So if I really appreciate the big picture view of the system and how you feel cases should be working through it. On the practitioner and the litigant side, it seems like one of the places where a lot of the action should be, where maybe it isn't, is around meet and confer. And so I know we kind of chose that as our legal topic for today. I think this is a good place to talk about it now, because we're talking about clearing that backlog, like Lauren said. What should really be going on in these sessions, not just to comply with the letter, the code, but in the way you talk about it, really the spirit of settling a case and doing it quickly?
Well, I think the letter of the code and the spirit are actually identical. When I was at Department of Water and Power, the rules of court require meeting and conferring. It's not just family law, it's civil law as well. And meeting and conferring in civil, my experience was on a Friday afternoon, I would get a fax letter. Your client which was the Department of Water and Power, is, dishonest, immoral, and is not in compliant with the numerous discovery requests, and stand on record that this is our meet and confer. And if I don't get it by Monday or Tuesday, we're going to court. And I guess the meeting part was that I went to the fax machine and picked it up. And the conferring part was that I read it. And, I'd call the person back, and of course they're gone Friday afternoon. They're not there. So that always was frustrating to me, because as the Department of Water and Power, nothing really is confidential. The union business aside, nothing's confidential. It's government records. So you're going to get it. I mean, how fast you can get them to go into the room and get it is something else, but you're going to get it. At least when I was there, you were going to get it. And so I found that was the puzzling. When I took the bench and I was in Pomona, I would indicate to people that on their RFOs that I wanted them, before I heard their case, they'd have to step outside and give me a joint statement of disputed facts. It didn't have to be, printed. It didn't have to be on legal paper. It could be on yellow paper. Just tell me the issues you agree that you disagree about. And I would send out, my orders that would have that language. So I was on the bench maybe week 2. And it was like my cousin Vinny. I can't remember the lawyer. I remember the face. Even if I did remember the lawyer, I'm not going to say it. That you're serious about that? Yeah, I was serious about that. I remember sanctioning somebody. And then all of a sudden I started getting them. All it is don't tell me you don't agree about anything. Of course you don't agree about anything. That's why you're here. But if it's support, is it, the income? Is it the time with a child? I mean, I don't need to know why. I just need to know the issues. Then we can address why when we have the notion. But the hearing. But what I used to get were 2 sets of briefs, and they were 2 universes. There's a jury instruction that says 2 people viewing the same incident or experiencing the same experience can have 2 entirely different versions of the same set of facts, and either person is lying. Those would be the briefs I would get. 2 different worlds. Oh, this is not an issue, but in the other person's brief, it absolutely is an issue. So once you get the people to sit down and, resolve what the issues are, surprise, surprise, many issues go away. And then you've actually self-honed the issues, and then it makes cases easier to either hear or go to drill down and settle. And, I would argue, even in our retreats once a year, make the parties meet and confer. And that's judicial. I mean, that's case management. So to me, it's instrumental. First of all, it's the rules. I make this stuff up. Second of all, when you do it, and I know it can be done because I've done it for 15 years, it narrows the issues. That doesn't mean the people have to agree. They never have to agree. I mean, some cases you can't settle and you have to go to hearing or trial on. But most cases, once you understand the issues and understand the numbers, for instance, the value of a house. I think the house is worth $2 million. Oh, I think the house is $4 million. Okay, you're $2 million apart. Oh, by the way, how much have you spent on legal fees? $1 million. Well, now you better hit it out of the park, because you're going to spend $1 million maybe to get $1 million, right? Because half of it is the other person's money. But that kind of risk assessment seemingly is rare, at least until they come and you sit down and make them think about it. So I think, to me, it's simple. To me, it's really simple. But I don't know that this is the philosophy of how most people approach their cases.
In your experience, what are some of the biggest roadblocks to settlement? I think you touched upon one already, which is sort of the fear that the parties feel on the emotional side of things. What else can hold up settlement?
In some cases, fewer than you might imagine, there's a power struggle going on. And typically what I've seen is the person who filed the case went through a lot of agony and grief to get to that point and wants out, and did not wake up one morning like the statute allows and decide, for instance, in a dissolution, I'm out of here. It was a lot of soul searching, but they got there. And then they served the other person, and the other person is surprised. It doesn't matter how many times they were told, do this, otherwise I'm leaving. The person didn't leave. And so usually what breaks up the relationship is nothing as bad as what, they've been through before. And so the person who's the respondent feels betrayed, feels sucker punched, and feels abandoned, and is angry. And it doesn't matter if it's a woman or a man. I've seen both sides react that way. I'm sure as counsel, you've seen it too.
Certainly.
So you've got the person angry and they want revenge. And I've often called my settlements icebergs, and I need to find out what really was the linchpin. Even though it's a no-fault state, you've got to find out what's really hanging this thing up. And it's not what they've told the lawyers. It's not the girlfriend. And it's not.
How do you do it? How do you break through that roadblock?
I let them vent. I try to figure out who's having the trouble. Because if it's the petitioner who filed and wants out, usually those people are willing to give more just to get their freedom, and oftentimes unfairly more. But the other person has to be heard. And so number one, I let them vent, because they could never vent like this in court. It's irrelevant. And number two, what they want most, their possession of choice, is it custody, whatever it is. Unfortunately, most often I think it's money. Even the child, it's money. It's money. And I'm not saying there isn't domestic violence, don't misunderstand. But most of the cases where it's falling apart is money. And even in cases where the petitioner is done, I have rarely found the petitioner ever having a plan. They don't have any financial plan or thought in process. I shouldn't say never. I had one recently where the woman clearly went to school and got herself a degree and got herself a roadmap to be done. And the husband said she was planning this. And I said, yeah, I think so. I think that's right. She clearly did. Yeah. But 15 years, I mean, maybe on one hand, I've seen that. Most of the time, the person who files genuinely believes that everything's going to be the same or better with two different households. And the dilemma in all of this is that some lawyers believe their client beyond reality.
What should a lawyer be doing to set the right expectations?
Right. Some lawyers believe their clients, and I don't think the clients are lying. I think that's the biggest dilemma for the attorneys. They think the other side is lying. Cases I've had, most 98% of them, those people, all of them would pass a poly because they genuinely believe what they've experienced. It's almost like my friends in the last 2 or 3 years, they watch CNN. So they get reaffirmed everything they believe. They would never turn on Fox, and vice versa. And I say that mediation is an opportunity to look at the answer book. Find out where your client may not be as strong. Find out where your client may have some flaws. I mean, in warfare, people send spies to the other side. Cops do undercover. What do you think Oh, now they turn the lights back on. mediation gives you that. Keep your thoughts about how horrible the other person is on the back burner. Just listen. Let them watch them. Listen. Because as somebody told me the other day, it equated me with a video I saw once in training. Apparently there was an AAML conference where they showed a video of parents, a mother saying what the child thought, and the father saying what the child thought, and then the child, totally different story, totally different. And parents tell me, oh, this is what my child thinks. Oh, this is what my child thinks. And I can tell you, after talking to many, many children without the parents in the room, all of the children agree with this. Their parents don't like each other, and that they feel that they have to make the parent happy, and it hurts them how much the parents don't like the other parent. Like an 8-year-old told one of the evaluators in one of my cases, my parents hate each other more than they love me. And when I tell parents that, they tell me, I don't hate the other person. Really? Read your declaration. That is not an opus to love.
So you opened it up. So let's move a little bit more on all these issues, whether it's dealing with the children, the financial things you mentioned, the fear, imagining the future, all these roadblocks to settlement. Has your approach or philosophy changed at all now that you're a mediator? How you try to communicate with the parties? Are you doing things a little bit differently within the cases now?
Yeah. When I was on the bench and people, I had a restraining order court as well as a settlement court. So I probably wouldn't get to the cases earliest 9:30 in the morning, my settlements. Sometimes 10, but no later than 10, between 9:30 and 10. And then there's lunch, and I would tell the parties to talk. Sometimes I would talk to lawyers at lunch, but most often in the last few years, no, because of COVID. And then at 4:15, I had to close down. Now, if I'm going to be, totally candid, yes, I went past 4:15, sometimes past 5, but I get in, a phone call the next day from Bobby Tillman, what, the overtime, and yeah.
It's like now they're shutting the lights off on you.
That's right.
Yeah.
But they turn them back on. But
yeah,
here,
just like now, yeah.
Yeah, but here I can keep going. And why that is important is that I don't care if you're in private or you're on the bench. 4 o'clock is the witching hour where people will first start to calm down and think. If I have to send them home, the next time they come back, it is an etch-a-sketch. I'm starting all over.
Mm-hmm.
And here I can get on the phone and talk to them. And most likely, if I can go to 8 or 9, I can settle most cases. They don't have to come back. But even if they are coming back, I can talk to them. I can keep the dialogue open. I can do it on the weekends. I can do it late at night. When I was on the bench and I heard that some of my former colleagues were doing that, I thought, how moronic is that? You have your own time, and why do that? But the fact of the matter is that when you're making your own calendar and your own cases, you have the luxury to say, okay, today and tomorrow, I'm going to be working on this case, but it'll be over. And most times it's over. And the attorneys appreciate the fact that they can call me and talk to me because I'm the mediator. And it gives you a whole lot more flexibility to be able to work with the people, not only allow them to vent, but to let them see that you're involved. When I'm wearing a robe, I thought there's a certain amount of gravitas to the robe, but they already know my title. And the fact that I'm, talking to them and they know that I was the judge, it's the best of both worlds. They know I was the judge. I'm still me. I'm telling them, I don't think this is going to work. I mean, that's still happening. But on the other hand, they're able to tell me, in as much time as they need, why I'm wrong. And I think that helps. If people are heard and they have trust in you, they may be willing to agree to something that previously was unthinkable.
How do you get parties to trust you? What do you try to communicate to them to open them up to settlement and resolving the case?
Well, first of all, I listen. I let them tell me about everything. And even if I think, which believe me, I have, and I'm sure you have, what they're telling me makes no sense. And I don't find credible. They need to be heard before I can tell them that. They absolutely need to think that. Second of all, I tell them I understand where they're coming from, because with rare exceptions, I do. I don't agree where a lot of them are coming from. And that is a big mistake I think all of us as human beings have. I have friends who voted for the last president, okay? I don't necessarily agree or, whatever it is, but I understand why they did. And I don't think they're horribles. I get why they did it. I just don't agree. And I think when people believe you, that you understand where they're coming from, and you can tell them you understand, but that these are the reasons why there may be problems, I think that's how the trust is built. I use the example of Ruth Bader Ginsburg and Justice Scalia. Almost every case. These are two people who couldn't have been farther apart, on the planet, in the solar system, but they were best friends. How could that be? Politically, philosophically, they were so far apart. But with music and art and just being appreciative of each other's, good traits, they were friends. And I've told people, there's only two reasons I have learned that people break up. And to quote Tina Turner, love's got nothing to do with it, because I've divorced a lot of people who still love each other. They're crying. It's a lack of respect and an inability to communicate. Meaning, you need to know where the other person is coming from. And I think some people are afraid to hear where the other person is coming from. Even in our own personal lives, there are people who say, I don't want to talk about it because it's too painful or whatever it is, they can't go there. And you might be able to go there, but they can't. And, so many of the people who come in front of me say, I've told them 1,000 times, if this could happen, it could work. The fact of the matter is that person is incapable of either expressing themselves, thinking that way, or being that way. I used to tell my daughter, you cannot turn, with guys she dated, you cannot turn a couch into a chair. Guy's a couch. That's it. Cut off the arms, whatever it is, you got to cut up couch. But, no, you can't make people what they're not. And, when you're young, the feeling is, if they love me enough, they'll change. People don't change. And people come to scenarios like child custody or parenting or spending money with totally different wiring. We're all different. Even people who grew up in the same house have different wiring as to those things. And it doesn't make me right or you wrong. And I tell people there's no answer book anywhere on the planet. It's just an opinion. And, jerks get to be parents. Lots of jerks get equal custody. Doesn't mean that they're ever going to parent the way you think. But, oh, by the way you think doesn't make it right. When I was a child, Dr. Spock, and you put the babies to bed on their stomach. Oh my God, they'll take kids away now. Children have to be on their backs, right? Yeah. Even when they can flip over, right? I mean, everybody was fed a bottle. La leche didn't exist. And the joke, when I was in Pomona, I had fathers in paternity cases who were on parole for murder and gang murders, and they'd come into court just fit to be tied because the mother of their child wasn't putting the kid in the car seat. This was the one law they chose to obey.
So within your world now, right? If we limit it to a little bit more to the confines of the mediation process, if you're a practitioner, what would your advice be to practitioners in terms of dealing with either opposing counsel or the actual party, where you can let them vent, you can try and understand where they're coming from, even if it's not reasonable, they're just not going to get there. How do you do it? How should somebody be dealing? You want to get to settlement, but how should you be dealing with the other side if they're not necessarily just being jerks, but just really on another planet?
That's a challenge I deal with almost every day, because I go back to believing your client. Your client's got an explanation. It might not actually be that way. What they're telling you is not how it may end up in court. And you may be the most incredible litigator. Incredible. But client control, that is something that is just, it's like controlling Mercury or the wind. Anybody who tells me, oh, I have 100% client control, I think is on crack cocaine, because it's just, there's always a client that's going to go sideways on you. And so you have to know that. Number two, your client could be 100% right. Going back to, getting to a mediation. I have learned that if you explain to the parties, these are the potential things that could go wrong, you have to assess the risk. You don't have to believe me. But the thing I think that gets it sold, and I could be wrong, is this. I tell people going to trial is the equivalent of going to Vegas and putting it on one number, everything on one number, not a color, because a color got 50%, a number. And then I say, the second time you went to Vegas, it didn't look like the first time, because the owners of the casinos and the owners of the hotel took the money that you put on one number, imploded the old place, and built a new one. That's how obvious it is that you're going to do that. And even if you win, you could lose on attorney's fees. So I explain the risk, and I explain to them that you could be 100% right. I agree with you. If I were hearing the case, I might agree with you. But let's go back to our old MCLE training, where we would go to conference rooms or ballrooms in big hotels with tables for 10 and the clicker in the bowl with a clicker in the middle of the table. And you would talk about various cases, division of property. So you've got White Zuckerman up there, and you've got an esteemed judge, Tom Lewis, and or Scott Gordon, and you've got, the greatest lawyers of all time. Sorrel Troke comes back, and you got Ken Black up there too. So you've got Heaven's panel, and you pose the question, and they've all discussed it, and then they say, okay, get your clickers. Let's see who's going to rule like Judge Gordon, who's going to rule like Judge Black, who's going to rule like Judge Lewis. And you get those pillars, 20%, 30%, 27%, and then the
Basically
other
evenly split.
Evenly split.
Yeah.
How comfortable are you? Really? That's where it is. And all of them can write bulletproof opinions. So you want to chance that? Because nobody hits it out of the park in family law. There are no home runs, because I have watched them win and then pay the attorney's fees, which was more than they could have ever settled for. And not every case can settle, but I genuinely believe more cases can settle, because I'm here doing it. And so are others who are doing it on the bench and off. And the reason they're doing it is because we have the time. And that is the one thing the court doesn't have, is the time. We have the time. And if I live to be 120, I'm going to keep saying, bring cases sooner rather than later, because later the heels have dug in The hurt has gotten worse. And in the case of children, I mean, they might as well be Kiev, and it's winter and the Russians are turning off the heat. And I don't mean to be overly dramatic, but talking to enough children, that is what they're going through.
So one last question on this topic before we transition to our last 10 minutes here. What do you want attorneys or parties to know about you if they're going to go to private mediation with you?
Good question. As I stated, I have a process. I first talk to the lawyers before I do the mediation together so that I get some insight as to what their problems are. And I want them to tell me, not with their clients, just what is it that they expect and what do they want. Then I want joint statements after that, so that after we've talked, that they can hone the issues. And the briefs that I want, I underscore brief. I'm not looking for them to spend their money telling me something they've already told me on the phone. The downside of being in private is I don't have the files. So I would rather than the brief, the petition, the response, the financials, if those are an issue, restraining order documents, any type of evidence that you might have so that I can look at it. Historically, when I was on the bench, I could go into the court system, read it all and be ready. But I have found invaluable the time I take in reviewing the documentation and seeing what's there helps me. And then I call lawyers if I have a problem before the mediation so they can explain to me, an issue I might have. It's very interactive. Before I started working at ADR, Lucy asked me to go to Pepperdine and take that course, which I did. And it was helpful on the bench, but they teach a collaborative method. And a lot of it is, there's a mediation program in Pittsburgh where they sit around and have candles and incense. And they said that after 5 sessions, they get to settling a family law case. I think I'd be looking for razor blades. I mean,
that doesn't strike me as your style.
No, and so I went back and when I met with Lucy, I said, you probably don't want me because I'm very, very evaluative. No, that's what we want. So people who know me know that is, I explain what the risks are and what I think, but I always filter it with, I could be wrong because of several things. How people present in mediation very well may not be what happens on the bench. And I had a case, and I don't know if this is appropriate time to talk about it, but there was a case that came to me with a restraining order that was horrific. I mean, drugged, sex, and rape, and all sorts of allegations in the request for restraining order. And I didn't issue the restraining order, but based on what I read, I mean, I was wondering why the DA wasn't looking at this. It was so horrible. And the attorney for the defendant walked in and I said, look, you're not together. This was a relationship that apparently broke up 6 months ago. Maybe the victim would want to continue this for 6 months and not have a restraining order, but I don't know, the DA may be looking at this. And the victim said, yeah, continue it, for 6 months. The DA wasn't interested, which at that point I couldn't understand why. And the attorney for the defendants responded, said, no, we're going to trial, and had boxes and all sorts of evidence and binders. And I'm thinking, are you sure? I mean, I was pretty convinced that there's no way this could be a denial. And then the evidence came in that this was an online sex relationship where she was looking for the sex, she was looking for the drugs, she was looking for the types of sexual acts. She wanted to know if the drugs would work. She testified that on a number of occasions she would drink and use drugs to the point of passing out and then have sex. So there was no line of demarcation on the day in question, which they'd already broken up, and she went to him. So I denied the restraining order. But on paper, no. So I know that you have to always be open to how things can massively change in a hearing.
I guess I can't believe how fast this hour went. I wanted to talk about growing up in LA and becoming an attorney and your time, especially in terms of DV law and how that's changed. But instead, since we're up against it, let's finish with one more question. With all of this experience, what advice would you give to new attorneys starting out in family law? Obviously, settle is coming through, and focus on that. But day to day, what advice would you give to those people who are just getting into the field and committing to family law?
I didn't tell you this. I would tell them to go sit in a criminal court and watch someone criminally try a domestic violence case.
Why?
Because first of all, you learn about how to present evidence, because DAs and public defenders know how to understand the evidence code. And what's more is you'll understand how to question a victim and the issue, what they look for. Now, the burden of proof is much harder in a criminal case, but I think that the challenge that most lawyers have is they don't know how to try a case. And I don't mean that in a demeaning way. They don't understand how to put difficult people on the stand. And I think if they spent a week just watching a court doing domestic violence, it would be an invaluable experience.
Makes sense. Nobody's ever told us that before.
Yeah, that's definitely a unique piece of advice, and a great one. Well, thank you so much for joining us today. We're unfortunately out of time. Everyone, please mark your calendars and join us for our next episodes. They're all at 12:30 p.m. first Wednesday of every month. As Dan mentioned at the top, we have Peter Walzer, Samantha Klein, Glenn Schwartz, Judge Scott Gordon, who got a couple shout outs during this program, Stacey Phillips, Grace Jamra, and Michael Hanasab, Aaron Gray and Chelsea Stevens, and Judge Harvey A. Silberman. We want to thank Genna, Kathleen, and Belinda at the bar, the Family Law Executive Committee led by upcoming guests Aaron Gray and Chelsea Stevens, and of course our section sponsors. Most importantly, again, thank you so much, Your Honor, for being here and sharing so much with us.
Thank you. I enjoyed it. Thank you so much.
All right. We'll see everyone in 2023. Happy holidays.